No exceptions are allowed. Case law, M. Mehta v. Union of India. Facts. The management tried to rely on traditional exceptions of strict liability such as act of God and absence of negligence. It was argued that strict liability principles under English law should apply. The court examined whether such exceptions should protect industries dealing with dangerous substances in India. Held. The court rejected all exceptions and held that absolute liability allows no defenses. Once damage is caused, the enterprise is liable regardless of circumstances. This marked a clear departure from the rule in Rylands v. Fletcher. Strict liability. Meaning. Strict liability means liability without fault, but subject to certain exceptions. It applies when a person keeps a dangerous thing on his land for non-natural use and it escapes causing damage. Nature. This rule originated in English law. The defendant may avoid liability by proving recognized exceptions such as act of God or act of third party. Scope. It applies generally to individuals and enterprises and covers escape of dangerous substances from land. Case law, Rylands v. Fletcher, 1868. Facts. The defendant constructed a reservoir on his land for industrial use. Due to latent defects in the ground, water escaped and flooded the plaintiff's neighboring mine, causing heavy damage. The defendant had taken reasonable care and was not negligent. Held. The House of Lords held the defendant liable under strict liability. It ruled that bringing a dangerous thing on land for non-natural use makes the person liable if it escapes, even without negligence, subject to exceptions. Absolute liability. Meaning. Absolute liability means complete liability without fault and without any exceptions. It applies to enterprises engaged in hazardous or inherently dangerous activities. Nature. This rule was developed by the Supreme Court of India to meet the needs of modern industrial society. No defense or exception is available once harm is proved. Scope. It applies mainly to hazardous industries such as chemical plants, gas factories, and other dangerous enterprises. Case law, M.C. Mehta v. Union of India, Oleum gas leak case, 1987. Facts. Oleum gas leaked from Shriram Food and Fertilizer Industries in Delhi, causing serious injuries to workers and residents of nearby areas and resulting in one death. The factory was engaged in hazardous chemical operations in a densely populated area. Held. The Supreme Court held the enterprise absolutely liable for the harm caused. It ruled that industries engaged in hazardous activities have an absolute and non-delegable duty to ensure safety and must compensate victims without any exception. Key differences. Fault. Strict liability does not require proof of negligence but allows defenses. Absolute liability does not require proof of negligence and allows no defenses. Exceptions. Strict liability recognizes exceptions such as act of God, act of third party and plaintiff's fault. Absolute liability recognizes no exceptions. Origin. Strict liability originated in English law. Absolute liability is an Indian judicial innovation. Application. Strict liability applies to escape of dangerous things from land. Absolute liability applies to hazardous or inherently dangerous industries. Standard of liability. Strict liability is comparatively less stringent. Absolute liability is more stringent and uncompromising. Conclusion. Strict liability and absolute liability both aim to protect society from harm caused by dangerous activities. However, absolute liability is a stricter rule evolved to ensure better protection and compensation in cases of industrial disasters. Understanding their differences is essential for LLB examinations and practical application of tort law.